morning, distinguished ladies and gentlemen, our specially invited guests. Welcome to day 3 of the annual conference of the Rule of Law Development Foundation, centered on criminal law review. You will agree with me that so far we have had an action-packed 2 days, particularly yesterday, where we dealt with recent developments and new vistas in criminal law, both from the substantive aspect of criminal law, and later in the afternoon we went procedural. And we had various eminent personalities who gave us thought-provoking papers on these two aspects of criminal law. Particularly of note, it was chaired by no other person than Yusuf Ali, SAN, and then we had a later session chaired by Mr. Izion, and we had various contributions and even papers from our coordinator, JB Daudu, Senior Advocate of Nigeria, Rotimi Jacobs, JS Okutepa, Chinuo Abiagun, and Sam Ologunrisha, SAN. We also had papers from EC Ukala and DC Dewungwe. So you agree with me that yesterday was indeed very action-packed. And today, we continue along the lines. Today we are dealing with the topic of evidence. Evidence, which is an essential part of criminal law practice. Without evidence, the prosecution cannot prove its case. Without evidence, the defense cannot rebut the prima facie case, if any, made by a prosecutor. So it's important to deal with this key aspect of criminal law practice. And we are kicking off the session with core updates on electronic evidence. And my duty now is to introduce the panel and hand over to the chairman. Starting with the introduction, the chairman of this session is no other person than an eminent senior advocate of Nigeria, a friend of the chambers of JB Daudu and Co., and a friend of the Rule of Law Development Foundation, in no other person than Ahmed Raji, Senior Advocate of Nigeria. Let us give him a round of applause. He will be conducting the proceedings today. And our lead presenter is no other person than a justice of the High Court of Kogi State. He is a specialist in the area of electronic evidence. He has been with us from the inception of the Rule of Law Development Foundation. And he will be here to give us the lead paper on core updates in the area of electronic evidence. I am talking of no other person than Honorable Justice A. Ajileye of the High Court of Kogi State. You're welcome, sir. And to discuss my law's paper, we have two eminent interventionists who are senior advocates of Nigeria. And we have the first, Paul Erokoro, senior advocate of Nigeria. Seated beside my lord. He will be intervening on the paper. And then we have OEB Offiong, senior advocate of Nigeria. He will also be intervening. All their papers are available to all our conferees. Our conferees online on Zoom, I also greet you. And today, we're also joined by the coordinator. We can see the coordinator there. Mr. Daudu, good morning. And other eminent seniors who will also intervene when, as the chairman directs me. We will also be live today on Facebook, and eventually we will share the link for those who want to join us on Facebook and indeed YouTube. So indeed, we are streaming this program live for Nigerians to benefit as well, and our conferees. So, Mr. Chairman, without much ado, I hand over the session to you. I'm most grateful.
Good morning, Justice Akileye. It's a great honor and privilege to have you here. My able seniors, Mr. Paul Erokoro, and my leader from the source, OEB Ofion of Kanofe. Ladies and gentlemen, I welcome you all to this session. It's a very, very important one in the sense that this is a digital world, and the importance of, because electronic evidence, let me use the banker's terminology, is a broad brand that keeps developing and growing, just like technology itself. And in this modern world, for the legal system to cope effectively with the trend, there is the need to have in place something to tap into the technology. And how do you do that? Electronic evidence is one of the methods. I give you one or two instances. In the area of tax law, in the world today, one of the challenges is online trading, through which a lot of consumers avoid VAT and what have you. But with electronic evidence and what have you, such loopholes may be plugged. Also, a lot of banking transactions take place now online without convergence or a kind of harmony between law, practice, and technology by way of electronic evidence. A lot of things may not be proved. Then, voting. The world is moving gradually towards electronic voting. How do you prove this one in court when there's a dispute? This is where electronic evidence will come in handy. And then commercial transactions. A lot of us will do a lot of things online nowadays. So with these as the opening remark, I will not want to encroach on the sacred assignment given to my noble Lord. I will leave the floor open for my noble Lord to give us the I know he's going to do justice to it, but our appetites are wet already, and we hope we'll learn a lot as usual from his lordship. I therefore invite my Lord, Honorable Justice Akileye, to deliver the paper. Thank you very much, ladies and gentlemen.
Thank you, Mr. Chairman. Ahmed Raji, Senior Advocate of Nigeria. Distinguished discussant, Paul Erokoro, Senior Advocate of Nigeria. OEB Ofiong, Senior Advocate of Nigeria. It is a great delight having such a distinguished panel having to discuss my ordinary paper. I feel privileged. I'm glad to be here once again, and I consider it a mark of great honor to be invited to lead the discussion on the topic, judicial updates and legislative development, core updates on electronic evidence at this third annual Criminal Law Review Conference of the Rule of Law Foundation, ROLF. I say here from the depths of my heart that I have never taken any invitation of ROLF for granted. Since its inception, it has provided a forum for an annual assessment and evaluation of judicial and legislative developments in criminal justice system and policy of this country. It has enabled
serious questions to be addressed. And of course, with a very high degree of depth, time, and combined intelligence of intellectuals and jurists with breadth of legal experience. It has so far ensured that criminal law is very clear, is principled, and suitable for our modern times. In the last 3 years, I am aware that this conference exists to allow leading jurists, lawyers, experts, and others at cutting edge of issues in the area of criminal law to come together and engage in true dialogue in an effort to move the law forward in a reasoned and just way. Perhaps I should just quickly add here that our task should go beyond dialogue here. We should devise means by which whatever we discuss here, is implemented. Invariably, we always come across the need for legislative intervention in so many areas of our law. So, just coming around to discuss yearly like this without any further step to effectuate, such legislation may not be the best thing. So I want to advise we should move just a bit further. It gladdens my heart to announce here as a tribute to the Rule of Law Development Foundation that the publication of my recent book, A Compendium of Cases on Electronic Evidence, Volume 1, 2012 to 2019, is a product of the past 2 conferences organized by ROF. It was the challenge that I received through ROF's invitations to update the law of electronic evidence that I discovered such a large volume of materials of electronic evidence available but sprinkled over most of our law reports. I was therefore inspired to take up the challenge of compiling the cases into 1 volume of a book. And my basic object is to develop and build up the corpus of the law of electronic evidence in Nigeria and make the principles of the novel law easily understood, accessible, and locatable. I therefore owe ROF a debt of gratitude in providing the intellectual environment for the publication of the book. I want to request a round of applause for ROF. You have been carried away by my introduction. All right, so in fact, very boldly I say that without ROF, there would have been a compendium of cases on electronic evidence. My original idea, indeed, was to dedicate that book to the Rule of Law Development Foundation as an acknowledgement of invaluable contribution and investment to the advancement of criminal law in Nigeria. However, in the course of working on the book, the cold hands of death took away one of the best friends of the Rule of Law Development Foundation, in person of the late Honorable Justice Nasiru A. Ajana, Commander of the Order of Niger, Life Bencher, and Chief Judge of Kogi State, 2009 to 2020. He died on 28th day of June 2020 after a brief illness. I am aware that in his lifetime, he was a passionate and fervent, committed lover of this project. And so, with the concurrence of the coordinator of the Rule of Law Development Foundation, Mr. Joseph Bodurin Daudu, SAN, the book was eventually dedicated to Honorable Justice Nasiru Ajana as a token effort at memorialization of his name and his iconic contribution to the legal profession in Nigeria. May his soul rest in peace. And I want to personally acknowledge and express gratitude to the coordinator of ROTH, Mr. Daudu, for this singular effort at developing the law, particularly in the area of criminal law in this country. So I just go straight to my paper. My paper is actually divided into 3 parts. I've settled with the first part, which is the introduction. Then there is the judicial update and the legislative update. The legislative update, I caption it legislative framework. In the course of time, I now discover the appropriate caption should have been absence of legislative framework. So we begin with judicial updates on electronic evidence. I begin by saying here that the law of electronic evidence is gradually taking a definite shape. We all know the chaotic situation that we experienced in pre-2011 era as regards admissibility of electronic evidence. So I have discovered that we now have emerging from decisions of the Court of Appeal and the Supreme Court basic principles that on electronic evidence. And the effect of all the existence of this is the fact that the cloud of uncertainties over the application of the law of electronic evidence at its threshold in Nigeria is now steadily clearing off. So there now exists flexibility in the approach of courts in interpreting the extant statutory provision relating to admissibility of electronic evidence. And all this constitutes an enduring testament to the vibrancy of the legal practitioners and the industry of Nigerian judges. So I have highlighted some of the judicial updates under this subtopic. And the first one that I want to discuss here has to do with the mandatory requirements of oral evidence under Section 84(2) and certification under Section 84(4). When the Evidence Act 2011 came into being, there was this problem regarding the best approach to treat admissibility of electronic evidence, whether or not a certificate, mere certificate, is sufficient, to tender such evidence, or oral evidence was needed. But then, before I go into that issue, a preliminary point has to be made here, by recalling the fact that the enactment of the Evidence Act 2011, and particularly the incorporation of Section 84 into it, constitutes a new paradigm in the treatment of electronically generated evidence. The Act, for the first time, acknowledges and recognizes the existence of electronic evidence. Section 84 of the Act addresses a broad spectrum of legal issues relating to admissibility of electronic evidence. And specifically, Section 84(1) provides for admissibility of a statement contained in a document produced by computer. Then we have subsection 2 of that Section 84, which enumerates 4 conditions that must be satisfied before a statement becomes admissible. Of course, very briefly, we can mention these 4 conditions. The 4 conditions can be broadly divided into 2 They relate to the authentication of the computer that produces a document and the authentication of the document itself. The first condition under section 84(2)(a) is about the computer, that there must be proof before the court that the computer that produced that document is reliable. And how do you test the reliability of such a computer? There must be proof that that computer is being regularly used. If a computer is being regularly used, it will be taken that it must be reliable. Then subsection B, that is 84(2)(b), is about the document itself, that the document must be authentic, that the document must be reliable. Then subsection 3, 84(2)(c), also presupposes the possibility that a computer can malfunction, but then a fact has to be established before the court that in respect of the document being tendered before the court, the computer did not malfunction. Of course, we know if a computer malfunctions, it will produce something else. I don't know if you have experienced it. I had experienced it before. If you see a malfunction, a computer that is infested with virus, if you print anything out, in fact, what is printed will be unreadable. So there must be proof before the court, because the law presumes that it is possible that a computer malfunctions. But then you are establishing the fact that even if that computer ever malfunctioned, the malfunctioning of the computer did not affect the production of that document. That is the third requirement. So it's also about the computer. And of course, about the document. The last is about the computer again, that the computer is capable of producing the type of document that is being tendered. For instance, a computer in a bank will regularly produce statement of account. The computer in my court will regularly produce judgments and rulings. So the type of document that you are tendering, there must be a fact establishing the fact that the computer produces that kind of documents. And of course, there is also the requirement under section 84(4), which is production of a document of trustworthiness of the certificate, of the computer. Again, the certificate you are producing before the court to support the oral evidence under section 82. Of course, I have to add here that from the decision of the Supreme Court in Kubo and Dixon, we have gotten the fact that oral evidence is required to establish the 4 conditions which I have just enumerated earlier. Then you have a certificate to be produced under section 84(4). The certificate must satisfy some conditions. 1, it must identify that document. 2, it must show how that document was produced, giving particulars. Of course, the third condition, you must give the particulars of the computer that produced the document. And the fourth condition is, and there's always, from experience that I have in court, I discovered that normally people fall into the error of going about reproducing all the conditions stipulated under section 84(2) into the certificate. But if you look at section 84(4), there, all it requires you to do is just to bring about any of the conditions stipulated, any of them. So it is sufficient to have in your certificate just the fact that your computer never malfunctioned when it produced it. And of course, the fifth requirement of the certificate is that it must be signed by somebody who occupies a responsible position in relation to the computer that produced it. So people also fall into the error of thinking that the person, for instance, in a bank, the one who has to sign a certificate, because the law says a responsible person, but the law does not say a responsible person, but a responsible person in relation to that computer. So, which means computer operator in the bank is capable of signing that document because his or her position must be considered responsible enough in relation to the workings of the computer. So these are the requirements that are to be established in order to render an electronically generated evidence admissible. So I mentioned here, one of the earliest challenges experienced in the application of the law bordered on the issue as to whether or not it is sufficient to tender a certificate. People would just think a certificate was sufficient. Then there were others who then thought again that you needed oral evidence. So, but I have made the comment here that it is now heartwarming and cheering to observe that Nigerian courts are now coming to terms with the mandatory requirements of Section 84.2 and Section 84.4. The position I am to update and to update the law in respect of admissibility of electronic evidence. The first point I want to make here is that we have reached a level in which you have judicial authorities that establish the fact that in order to render an electronically generated document admissible, you need oral evidence under Section 84.2 and you need a certificate under Section 84.4. The two conditions are mandatory. I have so many authorities there. Ogunya, JCA, in this impact solution, this is what he said. Curiously, witnesses of the parties failed in their viva voce evidence. That is, there was no oral evidence in respect of the issue at stake, wrapped in their statements on oath. Of course, this statement on the conditions under Section 84.2, the oral evidence, in a civil case, they are to be located in the statement on oath of a witness because of the practice of using witnesses' oaths and fraud-loading of documents. So such oral evidence must be located in the statement on oath. So in this particular case, His Lordship is saying there was nothing, no oral evidence to establish that fact. And of course, that Section 84.4.2 was not complied with. This, therefore, the verdict rendered the document inadmissible. So without no, it is mandatory. In Brilla Energy Limited and FRN, the Court of Appeal acknowledged the prosecution's due compliance with Section 84.2 and Section 84.4. And the documents, the lawyers' reports, in that case, they were admitted because they complied with the two conditions. In Dixon and Silva, it is also on record the appellant also offered oral evidence and tendered certificate of authentication. In Islam and FRN, a computer-generated document was said to have been wrongfully admitted in evidence without an accompanying certificate of authentication, which means what happened in this case was that there was oral evidence, there was no certificate. It was said not to be admissible. It was expunged by the Court of Appeal. Similarly, in Imalen and FRN, exhibits C1 to C50 were expunged for non-compliance with Section 84.2 and Section 84.4. Also in FRN and Olutola, a computer-generated two computer-generated documents, Exhibit 5 and 7, were expunged from the court's record by the Court of Appeal. And in Rosehill and GTB, the Court of Appeal also held that the conditions stipulated under Section 84 of the Evidence Act cannot be waived. This is a pronouncement that is prominent. You cannot waive those conditions. The same conditions was reached by the same Court of Appeal in Neyo and the state. And in Collins Comex Nigeria Limited and Skybank, Obaseki Adejumo JCA re-echoed ACA's JSC statement in Silva and Dixon that the correct interpretation to be given to Section 84 of the Evidence Act is that electronically generated evidence must be certified and must comply with the preconditions laid down in Section 84(2). Well, so many other cases. I reported all of these cases in my new book. I will just draw my conclusion on this point here, that a valid conclusion that can be established from the foregoing is that a certificate of authentication on its own is insufficient to render an electronically generated document admissible under Section 84(4). Oral evidence under subsection 2 of Section 84 is mandatorily required to back up the certificate. I think we have got to that point. That is an update I want to bring to the knowledge of this August gathering this morning, that it is mandatory. We have so many authorities, mandatory that oral evidence under Section 84(2), certificate of compliance and trustworthiness of the computer under Section 84(4). So now I move to the second point, the scope of applicability of Section 84 of the Evidence Act. This question arises from time to time. Does Section 84, does it apply to all computer-generated evidence? As a matter of fact, in Omisore and Aregbesola, the issue there, the argument was raised that Section 84 only applied to internet-generated documents. Of course, we have to understand the background of this case, The first major case determined by the Supreme Court was Kubo and Dixon. And it had to do with two documents, Exhibit D and L. Exhibit D, Punch, online newspaper copy, and the other one, INEC list of candidates in Bayelsa State. So then, for a long time, between that period and Aregbesola, there was no other case. So the argument was raised that because Kubo and Dixon related to internet-generated documents, that it must mean that Section 84 only applied to internet-generated, but of course, the Supreme Court said no, that even the very chapter or the opening statement of Section 84 contradicts that type of submission. The relevant point here is a statement containing a document produced by computer. And so the Supreme Court held that computer-generated documents, all of them, they are applicable. Section 84 is applicable, to them. That is per Wednesday JSC. So accordingly, Exhibit 243, 342 in that case, they were held to have been wrongly admitted for non-compliance with Section 84. They didn't comply. So we have also had other cases that followed Omisore and Aregbesola, and the cases are Court of Appeal decisions of PDP versus Abiodun, Lale and Akombi, Rose Hill and GTB, Imale, where it was held that all computer-generated documents are subject to Section 84 of the Evidence Act. So again, I make the point as an update to a judicial update of electronic evidence, that we have gotten to a point, based on decisions of the Supreme Court and the Court of Appeal, that all computer-generated documents are subject to Section 84 of the Evidence Act. The third point I want to make here under this judicial is to ask a question. And that type of question had been asked, and courts had answered them. That if at the trial court there was no objection to admissibility of electronic evidence, can such a point be taken up for the first time on appeal? So, well, I have okay, sorry, I think that must be the last point I am jumping it. Okay, this point is, it must be proved that, okay, there's this requirement, there's the Court of Appeal decision in Zenith Bank, PLC, and NAC Oil. It must be proved that a statement containing a document produced by a computer before the provision of Section 84 can be activated. Okay, good. The point that is being made here is that should it be established that a particular document is produced by computer before Section 84 applies to it? The issue arose in Zenith Bank and NAC Oil International Limited, and the Court of Appeal imposes a duty on the proponent of an electronically generated evidence to establish that the document in question was produced by a computer. Let me create a picture, a scenario of this, that I want to tender this document. And in my pleadings, I did not identify it as electronically generated. Now, can the court treat it as electronically generated on its own? The Court of Appeal has said that it is required that to establish that the document in question, the proponent must establish that that document was produced by computer before Section 84 applies. I discussed it extensively in my paper here, but let me just read this aspect. The trial court upheld the submissions of the Customers Council, the bank, that it was computer generated. Since there was no evidence that the computer statement was produced by a computer, the statement did not require authentication. The effect of this decision is that it must be proved that a statement contained in a document was actually produced by a computer. Now, I have raised some questions in respect of the decision of the Court of Appeal on this point. And my queries are that for number one, there are some documents that by their nature, by their character, on the face of it, ex facie, you will know that this is a computer-generated document. For instance, you don't need anybody to tell you that a CD is an electronically generated document, or a DVD, or an email. If you receive an email, of course, the meaning of email is electronic mail. So it must have been generated by computer. So if you have such document before the court, are you still required to, if you don't say that it was generated by computer, does it mean Section 84 will not apply? So I raised this query that where it is found that by the nature of a particular document, it is computer generated, what can the court do? Then my second query is this. If somebody, well, mischievously does not want Section 84 to apply, and therefore does not, and keeps quiet about the character of a document, it does not say it is produced by computer, and the proceeding continues. So if he didn't say that, does it mean that Section 84 does not apply? Can't the court, looking at the document, come to a decision that this is computer generated? I raised the issues. And Well, I find answers here. My simple answer to this question is authentication is not a completely immutable and inflexible process, but may be accomplished in many ways. So there is no rigidity about what we are talking about. As a matter of fact, a document can be authenticated through circumstantial evidence. I have cited some authorities here, and particularly Loren versus Markel American Insurance Company, which the Court of Appeal followed in Brilla Energy Limited and FRN. And what it says is this, that there is no single approach to authentication that will work in all circumstances. But the best and the most appropriate method will invariably depend on the nature of the evidence and the of a particular case. So if we follow this, then it means you will agree with me as I agree with His Lordship Ogunya in Impact Solution Limited and International Breweries. What happened in that case was that the court had to physically examine the document and came to a decision. This computer generated. I want to quote His Lordship. He said, in total loyalty to the dictate of the law, have given a microscopic examination to exhibit A, B, C, D, blah, 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 sought to be expelled by the applicant. Note that His Lordship gave a microscopic examination to that document. Their email correspondence and messages, exchange inter-parties. His Lordship goes on to say, they fall squarely within the wide definition of document as ordained under Section 258. Then, they were procured from computer, which according to the definition denotes any device for storing and blah, blah, blah there. And again, any reference to it being derived. And it stems from those that the exhibits in question, they are classic example of internet or computer-generated document. So in this case, it was the court that examined, according to His Lordship, gave a microscopic examination to the document and came to the decision. This one is an email, and I have come to the conclusion that it was computer-generated. I say here, I agree with that decision. So, in other words, the point I am making is that even where a counsel does not identify a particular document as electronically generated, if the character and the nature of it, or the nature of it shows that it was computer generated, the court must be free to apply Section 84. And without necessarily disagreeing with the decision of the Court of Appeal in Zenith Bank and Akkoy, what the point of how I have reasoned is that the Court of Appeal in Akkoy's case, that statement may not apply as a principle of general application. So there can be some exceptions, and we have seen even from the Court of another decision of the Court of Appeal that there was an exception. So then the final point I want to make under judicial updates here is about the point I raised earlier, where no objection was raised at the trial court. Can it be taken up on appeal for the first time? I have two cases of the Court of Appeal which have established the point that an objection against admissibility of electrically generated can be taken up on appeal for the first time. The first decision is the same Impact Solution Limited International Breweries. And the second decision is Rose Hill, GTB and Rose Hill. But in GTB and Rose Hill, there was a dissenting judgment of the Court of Appeal. Ibrahim Shatta Bildia, JCA, held and was of the view that it is possible and it is proper to raise the point of objection for the first time in the Court of Appeal. And he or she, oh, it must be he, relied on Kubo and Dixon to come to that decision. Abiru JCA, in the same case, dissented. And he is of the view that it cannot be taken up for the first time on appeal. No, okay, I will just, permit me to just quote the two decisions now. Where Ibrahim Shatab Dilia, JCA, who read the majority judgment with concurrence of Adefope Okoji, JCA, held, quote, where evidence has been properly received in evidence at the trial, even where no objection has been raised, it is the duty of an appellate court to reject such evidence and decide the case on the availability of legal evidence. Cited so many authorities, and so Exhibit 1A, 1B, 26, and so on and so forth, having been properly admitted under Section 34 of the evidence, that ought to have been relied upon by in the determination of the appellant court, the counterclaim of the respondent, and on the fact that the conditions stipulated in Section 84 cannot be waived, placing reliance on Supreme Court in Kubo and Dixon. His Lordship held, in the recent case of Kubo and Dixon, the Supreme Court was emphatic that the conditions specified for the admissibility of computer-generated cannot be waived, nor can parties consent to the admission of documents without complying with subsection 2 of Section 84. That was the position. But then, His Lordship, Abiru JCA, dissented, and his own opinion was that it is settled law that by a long line of decision of the Supreme Court that where a document is legally admissible, but on the fulfillment of certain conditions, it is admitted in evidence without objection from the other party, even without fulfillment of the said condition, that other parties cannot later complain on the admissibility. These are contradictory positions. Well, it's a dissenting judgment anyway. His Lordship then again relied on the same Kubo and Dixon. Majority judgment relied on Kubo and Dixon to hold that you can raise it for the first time. The dissenting judgment relied on Kubo and Dixon to hold that you cannot raise it for the first time. This is Honorable Justice Abiru's position. His Lordship, in distinguishing Kubo and Dixon from the case under consideration, he said, the decision of the Supreme Court in the case of Kubo and Dixon relied upon by counsel of the applicant in seeking to contest this appeal of the admissibility did not interrogate, engage, overturn, overrule, or contest the above stated legal principles. The Supreme Court in that case restated the conditions to be fulfilled. So, and went on at the end of the day, the point of distinction was that in Kubo and Dixon, that document was tendered from the bar, whereas in this case, a witness came to tender it, and that same witness was cross-examined. And therefore, you cannot say that he did not have opportunity of knowing, counsel did not have opportunity of knowing that the document was not admissible. Coming up to the Court of Appeal to raise it for the first time, His Lordship disagreed. Well, my own comments, with due respect. It is interesting to know that both the majority and minority judgments of the Court of Appeal relied on the Supreme Court case of Kubo and Dixon to reach their decision. I say here that one thing that is clear about Kubo and Dixon is that the Supreme Court was very categorical in holding that the conditions stipulated under Section 84(2) of the Evidence Act, they are preconditions, quote, I'm quoting the Supreme Court, they are preconditions laid down by law, and failure to fulfill same will render Exhibit D and L inadmissible. So it seems to me clear, therefore, that in line with the majority judgment of the Court of Appeal, that those conditions set out under Section 84 cannot be waived. Well, service of processes by electronic evidence. This year, the Supreme Court decided this point. And one interesting point is even the manner in which their lordships, pronounce on it. Electronic service of processes. Well, for a very long time, His Lordship Ogunwumiju, JCA as she then was, in Continental Sales Limited, established the fact that electronic service of court processing has taken a very firm root in Nigeria. So this position received a very strong approval recently by the Supreme Court when Abaji JSC stated in Compact Manifold Energy Services Limited and Person that it will be strange for anybody to frown at being served electronically in this age of electronics. For any lawyer, to frown at being served electronically. His Lordship said that will be very strange. And again, Galinje JSA, as he then was, also added his voice. And what he said was that it will be foolhardy for any litigant to insist on being served with hard copy of hearing notice in this age of information technology and superhighway. Service of court processes by electronic means is collaterally associated with the current technology. So, these are some of the judicial updates that have come up in the last few months after we met here, which we have never discussed. And the legislative framework, which I will rightly describe as absence of legislative framework. That's the last point I want to make here. And last year, I bemoaned the absence of legislative framework on electronic transactions in Nigeria. I also highlighted the absence of rules regulating e-discovery. We don't have rules, we don't have format. In other countries, they have advanced. We are sitting here, nothing has changed. It is sad that the Nigerian law relating to electronic evidence is hampered by lack of legislative framework. All that we have, and we talk about every day, is Section 84, which essentially is only limited in scope, as it only addresses matters relating to admissibility of electronic evidence. And so, but in Nigeria today, we buy and we sell online. As a matter of fact, buying and selling online are becoming, the order of the day. You buy shoes, you buy electronics, you buy so many things online. Products and services are advertised, sold, paid for, and delivered through electronic platforms and websites on a daily basis. We have what we call Waka Now. It's a leading online travel agency. We do online transactions to travel out within and outside the country. We have Jumai, which is a popular online shop. We have Konga, which is another online mega store that delivers goods with speed and precision. And so now, with all these transactions, it is interesting and of course very sad anyway that we have no law regulating all our transactions. All the transactions that we carry out online, Bitcoin and what have you, cryptocurrency and so on and so forth, we do them at our own risk because there is no law regulating such. And that is a clear evidence of the backwardness of the law of Nigeria. It is not Nigeria that should be at this level. Why do I say so? As far back as 1996, the United Nations drafted what we call the UNCITRAL Model Law on Commerce and made it available to all countries to adopt, to regulate electronic transactions. Again, in 2000, the Commonwealth law ministers and attorney generals at their meeting, they also recognized that common law rules of evidence were not adequate to deal with technological advancement. An expert group was constituted, and the Commonwealth Model Law of Electronic Evidence, was formulated for member countries. Nigeria is part of the Commonwealth. Now, I have noted here that South Africa, as far back as 2002, they have their own South Africa Electronic Communication and Transaction Act. Our neighbor here, Ghana, in 2008, they enacted their own Electronic Transaction Act. And here we are in Nigeria today. We have no such law. So that is one problem that we are facing in this country. But again, I have noted here, in fairness to the National Assembly, they have made 2 attempts to enact this law. The recent one was in 2017, but the president did not sign the law. And again, today, I am also aware that there is currently another bill on electronic transaction. The Senate, at the Senate, being sponsored by Senator Ibikunle Amosun, it has passed through the second reading. My hope is that it will not abort like the earlier attempt. So laws relating to e-commerce, such as that we prohibit electronic fraud, protect critical infrastructure, and enforce antitrust, they have become overdue for enactment in this country. And I think I am throwing the challenge to the Rule of Law Development Foundation that this matter should be taken up, that hopefully before we meet next year again, Nigeria will have had our own version of Electronic Transaction Act. We can follow up with what Ibikunle Amosun is doing. And I conclude my paper in this way. The law of electronic evidence, like any other aspect of law, is dynamic. Its dynamism goes hand in hand with the evolving nature of modern information and communication technology. The development of this aspect of law can be achieved through deliberate judicial efforts. Judges have the duty and responsibility to be proactive and purposeful in interpreting the law. And as regards the absence of legislative framework for electronic commerce, I once again throw a challenge to the Rule of Law Development Foundation to rise up to the need for a closer cooperation and coordination of efforts between the National Assembly and the relevant regulatory authorities and government agencies, as well as the private sector, in order to facilitate the development of a robust legal and regulatory framework for electronic commerce. This should be taken as a worthy assignment for accomplishment before the next conference. I rest my case. Thank you for this. Thank you. Thank you very much.
It was never taught electronic evidence. So, and when we see quality, we have to recognize one. Another round of applause for my Lord. I took active interest as you read the paper because currently I'm studying taxation in England at Oxford. And one of the areas we are touching is on tax avoidance by way of digital online purchases. And as you are reading, let me thank you very much for the way and manner you have gone about it. You have really discharged and acquitted yourself. Um, Now, we're going to declare the floor open. And no, I know, but it will start with the lead discussants. I cannot, even if they are not discussants, since they are here, they are my bosses. One trained me in Kano, another one has remained my mentor here since I got to Abuja. Far back in Katsina since 1992, he has always been a mentor. OEB, Ofion, Ofion. We owe you a lot of gratitude, sir. So, Mr. Erokoro, I'm too small to time you. We're going to give you 10 minutes to summarize your contribution. Actually, after my Lord delivered the paper, I was wondering, what will anybody say again? But knowing you as you are, I know you have something to say. 10 minutes. Up to you, sir.
My Lord, I join the chairman in acknowledging the very high quality of your paper. And as the chairman has noted, it's actually difficult to add anything to your very comprehensive and scholarly work, but I will try. I did send in my paper, and you'll find it on page 169, I think, of the bundle. In view of the fact that I have just 10 minutes, I'll just touch on a few points briefly. Now, the first is introductory, but since this introductory point seems to have loomed rather large in His Lordship's presentation, permit me to point out that we all know what evidence is and its classification, oral, written, and so on. But if we take the bit about oral, documentary, and real evidence, I've made a point here that even a charge of theft of a computer, the computer is tendered in evidence. It's real evidence. However, the content of the computer is electronic evidence. Similarly, this gadget I'm holding up, if tendered in court, is a piece of real evidence. But we're not tendering it because of the beauty of the leather package and so on. You want the information inside. And I will touch briefly on that later on when we talk about authentication and so on and so forth. Okay, I thought it was my voice that was echoing. Mm-hmm. All right. Now, it's been suggested that the Evidence Act of 2011 introduced a new class of evidence called electronic or digital evidence. This point might at first appear to be academic. What does it matter whether it introduced new evidence or not? But as has been demonstrated in this paper, it turns out to be a very important question. So I will reframe it. Was electronic evidence inadmissible in Nigeria before the advent of the Evidence Act 2011? If the answer is that it was admissible, then the next question is, we did not have Section 84 of the Evidence Act then. We did not have those preconditions. So that evidence was admissible without compliance with the present conditions in Section 84. Did Section 84 come to change the law or to clarify the law? Now, this goes directly to the point about whether the Supreme Court ought to have held, as it did in Kubo, that the conditions in Section 84 cannot be waived. It seems to me that the law as espoused by my Lord right now is quite correct. That's what the Supreme Court said. The Supreme Court said there are preconditions. The wording of Section 84 does not say so. It says this evidence shall be admitted if these conditions are met. It does not say, the Act does not say that if these conditions are not met, the evidence is inadmissible. If we take the view After all, as far back as 1969, the Supreme Court said the law cannot close its eyes to the mysteries of computers. And Galinje said, look, we've been living in a jet age since the 1930s, and we must keep up with modern technologies. Why should it not be possible for electronic evidence to be admissible if the other side does not object? Now, I get it. The Lordship say there's evidence. So if evidence is absolutely inadmissible, then it is absolutely inadmissible. But we have had an exception to the rule that public documents can only be proved by certified true copy. We do have one exception on record. I didn't know this point would come up. I would probably have brought it up. But in a particular case where the public officer refused to certify the document, the Supreme Court held that in the interest of justice, that photocopy was usable. Where the public institution refused to certify it, but why should it be admissible if indeed it is absolutely inadmissible? So to every rule, there must be some exceptions. So I'm saying that if the law today, as the Supreme Court has said, if the Lordship will not review that position and take it that it should be possible to waive that condition, then perhaps there should be legislative intervention. And I will just devote the rest of my 5 or 6 minutes to that point. So His Lordship had said, when it is clear that a document is electronically generated, why should it be necessary for the proponent to first say so? And my Lord gave the example of an email and then of a DVD. Yes, obviously, an email, as the name suggests, an electronic mail, so it was electronically generated. A DVD, yes, it contains electronic evidence. But the DVD is first and foremost real evidence. It is a piece of real evidence. It's when you look into the content, because that content need not be on a DVD. It can be on a flash drive. It can be on the sound recording. It can be in any other format. So, if a party tenders a DVD in court and the other side does not object, suppose the other party even relies on it at the trial court. I'll ask another question. Now, virtually every piece of writing today passes through a computer in one way or another. Virtually everything that we deal with now. Typewriters are to a large extent gone. And if the definition of a computer is wide enough to include everything that can produce data, even the printer by itself, even when disconnected from a desktop or a laptop, the printer itself contains a processing mechanism. So in a certain sense, the printer itself can be a computer, depending on the context. Your watch is a computer. There is a mechanism that makes a trafficator in the car to trafficate left or right, left or right. There is a chip in there. So depending on the context, that might be a computer. So there is so much about what a computer is today that if we are not careful, we can take decisions that will lead to a lot of injustice. I, for one, feel that it is extremely unjust for a bank to give to its customer a statement of account. The bank deliberately refuses to comply with the provisions of Section 84, gives it to the customer tenders it, the bank does not object, he gets judgment, then the bank goes on appeal and says, oh, that piece of evidence was electronically generated and the conditions in Section 84 were not complied with. And then the court says, oh, well, yeah, that's true. And then the case is true. Now, that's patently unjust. So other principles ought to come in. Principles of equity, because the law must always flow hand in hand with equity. The bank should be stopped from making that point, even if the point is legally valid. The principle of estoppel should apply there to say, this point may be right, but you are stopped from making it. And I think that those decisions cited by Lord, extreme injustice was done by the courts there because they had a dogmatic attachment to the printed law. Now, yes, just to underscore that point, I had a matter where a bank froze a customer's account, and the bank said that it did so on the orders of the EFCC. So an action was taken in the FCT High Court against the bank and EFCC. EFCC came to court to say, you can't sue us in the Federal High Court. And the judge agreed and struck out the name of the EFCC. Then, when the case was about to start, the bank said, hey, it was EFCC that ordered us. Without EFCC, this case cannot proceed. And the judge was about to say, oh, that's true, I'm transferring the matter to another court. When a very young counsel stood up in court and said, no, you can't. EFCC was joined, you struck out EFCC, and now you're saying the suit is not properly constituted because EFCC is not here. So the court must be purposive. The judges must remember that the fundamental objective is to do justice to the parties and not to stand too strictly by technicalities. Just one last point before the chairman says my 10 minutes are up. Now, I have in my paper, just as the Lordship has said, drawn attention to the fact that Thank you. I've drawn attention to the fact that there just isn't sufficient legislative or regulatory provision as regards to electronic evidence. And I have enumerated here all the provisions that I know in the extant laws that touch on electronic evidence, apart from the Evidence Act itself. The Administration of Criminal Justice Act, where it permits reception of evidence by video link, and I've seen that in some cases in Abuja. I think Rotimi Jacobs did that in Yako versus FRN versus Yako before Honorable Justice Okonabang. The same ACJA says that the statement of a witness may be taken on an electronically, on a retrievable video compact disc or similar gadget. And then the Attorney General is ordered by ACJA to establish an electronic and manual database of records of arrest throughout the country. And then Section 3621, which says that court recordings may be recorded electronically or verbatim. That's the closest we have gone to having a legislative provision saying that our Nigerian courts should stop the disgraceful practice of still writing longhand in the 20th year of the 21st century. Anywhere else in the Commonwealth, court proceedings have been recorded verbatim electronically for almost 100 years. And then, of course, we have Section 17 of the Cybercrimes Prohibition Act, which simply says, concerning electronic signatures, that electronic signature in respect of purchases of goods and other transactions shall be binding. And then even the Evidence Act makes only an oblique reference to electronic signatures for something as central as that to today's commerce and today's transactions. So I have pointed out that the absence of regulation is causing a lot of trouble. And I'm showing what the UK has done, for example. The UK is relying on an EU directive, but even then they've gone so far as to tell you exactly what an electronic signature is and how it can be administered. They divided electronic signatures into two, the advanced and then the qualified. And for the advanced, they've given the criteria. You must, an electronic signature shall meet the following requirements. One, it must be uniquely linked to the signatory, must be capable of identifying the signatory, must be created using an electronic signature creation data that the signatory can, with a high level of confidence, use under his sole control, and that it must be linked to the data signed therewith in such a way that any subsequent change would be detectable. For qualified signatures, in fact, the UK is not even using them, even though it's there. Why? Because it requires a large-scale identification possibility, such as you have in America, where they have the Social Security number. So you know that your Social Security number, in fact, once a child is born, there is given a Social Security number. Our ID card scheme started 500 years ago, I think, and we still, many of us in this room, I'm sure, have applied and still don't have. So, as regards electronic signatures, the three problems have not been addressed in Nigeria by any kind of regulation. That's the identity problem, the authority problem, and the formalities problem. The identity problem, of course, is how do you know that the person who affixed this electronic signature was actually the person, the intended person? The authority problem is how do you know that the person who affixed it was authorized to do so, for example, on behalf of a company? And then the formalities problem. What if the law says that the signature has to be witnessed? Or what if there are preconditions for the signature to be used? I'm saying that if the National Assembly doesn't want to do something about it, then regulations should come in. Under a lot of those laws, there are provisions for regulations to be made. There should be. And then finally, I'd like to draw attention to a case cited by my law, that's Brilla Energy and FRN. Now, that was a remarkable case in many ways. If you recall, that was that subsidy scam where Nigeria had a budget of 4 trillion naira for that year. And then it was during Jonathan's time. He wanted to remove subsidy. And there were demonstrations all over the country. And the key point that the demonstrators were making was, subsidy is a scam. There is no subsidy. And the president set up a committee to look into it. Confident, I'm sure, that the position of the government will be vindicated. And then it turned out that about 990 billion naira, that's to say 1/4 of the budget, had actually been stolen, and the federal government did not even know. Yes. So, those of us who say restructure because the federal government has too much power, that point dramatized it. 1/4 of the federal government budget was taken, and the federal government did not know, meaning it had too much money. If you remove 50,000 naira from my account, I will know. Yeah. You may remove 5 billion from our chairman's account, he will not notice. But yes. So, but the point is that in that case, in this particular case, the company claimed that they supplied petroleum products to Nigeria and identified particular ships that brought the produce. Yes. They bought from Petrobras in Brazil, then there was a transshipment from one ship to another, and then the last transshipment was at Cotonou, and then the ship sailed to Nigeria and delivered the products. But the EFCC had a very simple approach to it. Lloyd's, the Lloyd's list is an authentic and a highly regarded thing. Lloyd's is able to tell you where every ship is in the world any minute. It will tell you specifically. And the data has proved very reliable over the years. And Lloyd said, oh, that ship was supposed to have been in Cotonou. No, it was in the United States of America at such and such a port, at such and such a time. Now, how did they prove it in court? The prosecutors came to court with their laptop and their projector and put it up. And then in court, used their own internet to connect to the Lloyd's website. The information was displayed on the screen, and it matched what they had tendered. The point I'm making is this: in other courts elsewhere in the world, the facilities that would have been used for that demonstration would have been court-owned facilities, so you are certain about the integrity. But here, the party to the case brings his own equipment, and the court is forced to rely on it. The court ought to have all of these. And we've also drawn attention to the fact that even attempts by our courts to utilize electronic methods have failed because of the absence of backbone. I give two specific examples. One, if you recall, the NJC rolled out a case management approach where every lawyer would have an email, a mailing address, and so on. It failed. And the court itself, the Supreme Court also established, in fact, they said by 2018, there would be advanced computing in Nigeria. They were going to design a case management software and so on. None of those things have taken off. Because the truth is that there just isn't enough investment in this field. So, my Lord, thank you very, very much for this extremely illuminating paper. And I will just end up by saying, concerning the difficulty of authentication and why there should be more regulations, I will use our own association, the Nigerian Bar Association. Gentlemen, how do you feel about the fact that our last two elections, which tried to rely on electronic voting, ended in controversy? Yes. It's so. So that's our best evidence that we need more in-depth regulation about these things. Because right now it's an all-comers game. It's possible that crimes are even being committed in this process. But because there are no regulatory, there are no rules, we have the same situation as the one I was invited by the Nigerian Society of Surgery to deliver a paper a few years ago. And I took only one aspect of it. I got there with 3 bundles of documents. One very high, the other medium high, and then the last one, a single sheet of paper. And I asked them, gentlemen, you've been performing transplants in Nigeria. Some of you have been doing kidney transplants. You've been doing all manner of surgeries. May I see your regulations? These are the United States regulations. Britain has about the same. These are the regulations in India. In Nigeria, you know what I brought here? The Nigerian Medical Act, that's all. The Medicine Act, that's all that there was. Not a single regulation. And yet, they were cutting people off and removing this, so on and so forth. That is about where we are as regards electronic evidence. We must have more regulation. Thank you.
Well, another round of applause for Mr. Eroko. Oh, thank you very much. And it's not unexpected. Anything less will have been unlike you. And we thank you for having the time to come and give us the talk. In the course of his presentation, something just flashed through my mind, and which I want to address to the chairman, is the famous case of Ariori and Elemo, which decided by the Supreme Court to the extent that all rights can be waived except those in the Constitution. Now, we're talking of Section 84 of Ordinary Statute. Well, how did the Supreme Court arrive at not it being waivable? In the light of an earlier judgment of the highest court of the land in Ariori and Elemo, I think it was 1982, where the Shaw categorically stated that, look, anything can be waived. Perhaps only the constitutional provision touching on right to fair hearing or something like that. But as regards any other ordinary statute, if you sleep on your right, and in addition to the issue of estoppel raised by Mr. Eroko SAM, so I want the chairman to please bear that one in mind when he's responding generally. Over to you, my boss. Eh? No, you are going to respond. So, over to you, my boss, Mr. OEB Opion. Thank you very much.
Thank you so much for having me. And I've always been challenged by height, so this is just a recent example. Thank you for the help. Thank you very much, Mr. Chairman, for your paper. And I think that, and thank you very much, thank you for the lead presenter of the paper. You know, the chairman has confused me now. It's creating double chairmanship. I think I join everybody in congratulating you for the quality of your paper. But let me also thank the chairman of the occasion for his very warm introduction. This is my first participation in this rule of law conference. So let me also thank the coordinator for the opportunity to be part of it. I think I pay a very serious price for my lack of participation in the past, because in understanding the subject of the discussion, I apparently focused not so much on core update on evidence, but generally on the impact of legislation on the criminal justice system. But the good news is that that's not the lead paper, and that is a lead paper. So I am able to pivot and discuss or make a contribution to the lead paper without having to bother about my own paper. So my contribution is not going to be very elaborate, but there are two key things I will try to speak on with regard to the paper. One of them is the troubling question of authentication under Section 84 of the Evidence Act, the Electronic Evidence. Now, there have been two decisions which have been somewhat troubling. One of them is the decision by the Court of Appeal in Jos Division. It was a decision in James Badun against the Commissioner of Police. Now, the interesting thing about the case and why it raised the question of electronic evidence was tendering of a photograph. And I'm grateful for the dichotomy which my learned friend, Paul Erekoro, has drawn with regard to real evidence and the content of the computer itself, which is the electronic evidence. Now, in Badun, incidentally, it was a murder case, which for those of us who have practiced all our lives in the North, we don't use that brutal word, murder. We call it culpable homicide. So it looks a little romantic and covers the severity of what has happened. But here is the interesting thing about it. Photographs were taken, and the issue actually turned out on the admissibility of those photographs because there was a crowd that descended upon the victim, the deceased, and caused the death of the deceased. There were many, so everybody was trying to isolate himself and say, no, I wasn't part of it. So the photographs then became an essential part of the evidence which the prosecution was going to present. And the prosecution tendered the printed copies of the evidence. It was admitted in evidence. And the issue then came up at the Court of Appeal. I will come back to the question of raising objection for the first time in the Court of Appeal. But for now, the interesting thing about it was that the Court of Appeal, in determining the authenticity of the physical photographs that were tendered in evidence, rightly in my view, held that the means by which those photographs were produced was electronic evidence. But then he went on to lay the rather very tenuous condition that in tendering the negatives, you also needed to tender the camera with which the photographs were taken in evidence. And I thought that if they bore in mind the distinction between which Mr. Erekoro has drawn between the content and the physical evidence, then the tendering of the camera itself would not have been a requirement for the authenticity of the photographs. Interestingly, they ended up rejecting the photographs on that account. So, yeah, they still convicted the man, quite all right. So maybe another evidence, but because our issue is about the electronic evidence, the handling or the authentication of the electronic evidence, that became a somewhat troubling aspect of the case. Hopefully, and my concern is that, you know, if you begin to require that cameras must be tendered along with the evidence, you probably would never have anybody wants to take photographs and which are going to be used in judicial proceedings, because basically it means that in the situation that we have, that is going to lead to the seizure of the camera, and you can imagine a photographer whose means of livelihood is the use of the camera. They probably will lose the camera for the duration of not only the appeal, so not only the trial, but also the process of the appeal. So I hope that there will be some, the jury is not yet out, that that matter is going to end up in the Supreme Court, and perhaps this aspect of the evidence would be dealt with. There is yet another case, which also, again, it all goes to the challenge, part of which my learned friend has highlighted, which is the fairness factor in the manner in which we burden those who are tendering electronic evidence, the authentication process required to tender evidence. This one was a case, Oyekomi against the Federal Republic of Nigeria. Again, basically what the Court of Appeal laid down was what you may call the double whammy. The Court of Appeal is insisting that, notwithstanding that the electronic evidence is produced by a public institution, it must fulfill two conditions. Fulfill the condition of certification as a public document separately and distinctly from the fulfillment of the condition of Section 84 of the Evidence Act. Again, the problem I have with that is, if what you require for authentication of evidence is one of which is reliability of the computer through which the evidence was produced. That computer, as His Lordship pointed out in his evidence, in his presentation, is presumed to be reliable on account of the regularity in the use of that computer. Now, the computer is in the custody of the public officer, and so you want to use that evidence, you don't have the opportunity of ascertaining the regularity of use of the computer. Wouldn't it make sense that if that public body has produced, or anybody else, for instance, in the example my learned friend gave, which is the bank, shouldn't it make sense that if the bank or that public body produces that evidence, it should be sufficient that they have certified that it's a public document, and therefore there should be a presumption of they having as well confirmed that it has complied with the Section 84 of the Evidence Act. Now, and that takes me to the two other points I make very briefly, and then I will try and run up on that. One is this issue of preconditions. You know, I know that the Ross Hill case was argued by my learned friend, J.B. Daudu, you know, so, and I'm sure he's listening. Now, the other thing about it is that the Russell case is a court of appeal decision. So the likelihood is that it is still going up. Its fate will be decided one way or the other up there. But in a conference of this nature, I think we are allowed to ventilate what our opinion is. So, and my thinking is, I'm more inclined to support Abiru, JCA. And let me give my reason for saying so. You know, I think one of the cases that I recall and I cite very frequently is Alade against Olukami. Now, I believe, if I remember very well, that was a judgment of Idigbe. And one of the things he said was this. He made two important points. One is a distinction between the approach to the admissibility of evidence in a criminal case and in a civil case. Now, and he said that in a criminal case, if the evidence is inadmissible, it is not, notwithstanding that it was not objected to, the court must reject the evidence if it is admissible, whether condition was met or was not met. However, in a civil case, where there are conditions which were to be met, and that brings me to this whole question of preconditions. Conditions to be met before evidence is tendered has always been classed as preconditions. So I don't know what made the terminology suddenly become more exotic than the ordinary meaning we've always attributed to the word precondition. But here is the legal point, namely that in civil cases, where the admissibility of a document is dependent upon the fulfillment of preconditions. And two, it is the duty of the opposing counsel, when that evidence is presented, to object to it. And where he fails to object to that evidence, and that evidence is admitted, in fact, is even worse where that evidence has been used by the party, but even leaving the question of the evidence being used by the party, and just dealing with the question of the evidence not being objected to. The rule seems to have been well established that you cannot raise that for the first time on appeal unless that evidence was on any ground inadmissible. And the only evidence that we knew that was wholly inadmissible was the public document, where you either produce the original, thank God now they've agreed that original can be produced, or it's certified true copy or secondary evidence without it. So it looks like it's putting a lot more burden on us in terms of this interpretation which the courts are given. And that brings me to the last comment I want to make, which is that, you know, the challenge I see with the evidence and electronic evidence and much of the legislative framework in Nigeria is that we have been very slow when it comes to legislative activities. A lot of the laws that we are relying on in Nigeria as of now are still the statutes of general applications. So whereas the English who made those statutes have long ago moved away from them, we still wedded to them. So the development which have occurred elsewhere have not come to us. So the challenge really is a bit of judicial activism. And that brings me to also the point which my learned friend Paul made, namely that if you look at the evidence, at the electronic evidence, courts had already shown a flexibility about admitting them. The challenge was that you had a lot of conflicting decisions of the court on it. So the advantage you have with legislation is that it usually puts a lot of clarity to the issue. And because legislative activity do not need to wait until an appropriate case has arisen, pronouncement to be made by the court, it can be a faster route to resolving our problem. So hopefully, the legislation will follow that. But in the meantime, courts must take that responsibility and begin to do what is needed. One of the things which, as we mentioned here, is what is the scope of electronic evidence? Is it everything that passes through a computer? Interestingly, Chief S.T. Horn, SAN, wrestled with this in his current book on the law of evidence, and actually drew attention to the fact that I think at least 2 jurisdictions, the Philippines, I remember as one of them, and I think New Zealand, have tried to limit that merely because the computer has replaced typewriter. Basically, that's what has happened. So that would not mean that anything that you type on the typewriter and then print constitutes electronic evidence. That what should constitute electronic evidence should not just be what you have imputed, but something which is having to be transmitted by electronic means to or generated by electronic, whatever those distinctions are. So again, I think those are things which we ought to pay some attention to, and it is the courts that would be able, in the meantime, in the stopgap period, to fill in the gap, just like the Philippine courts are doing from the presentation or from what S.T. Horn highlighted in his book. So once again, I want to thank everyone for the opportunity to be here and to be able to join in this conversation. Thank you.
You will notice I did not time him, because you must never time whoever taught you at any stage of your life. So thank you very much, Bofiong, and we thank you for the time and for, a very good delivery. And I'm glad you also disagree with the lead judgment. In that case, you are more in line with Abiru, I think, sir. And we want my Lord to have a second look at it, whether Abiru should prevail or the majority judgment should prevail. Well, we have had, before we come to the audience here, a lot of people have joined us online, taking advantage of technology. And before I go, you have said that our laws are old. You know, the Nigerian laws is like the wine. The older it is, the better. Oh, I don't drink wine, though. Don't. So I think that is why we relish in maintaining the laws as they have been given to us, and we care less about whatever it is going on in other parts of the world. And I'm very glad all the references made by my Lord to the international intervention by way of UNCITRAL model law or rules which have been given to us, but we have ignored rather than embrace what is going on. But we want to jump into the jet. We want the best cars here. We want the best everything here, but to embrace the rules that will make a modern society, we have refused. My Lord, there is a comment, and this is the comment by one Richard Iyibo. And he said, "My Lord, there seems to be a wide array of documents capable of being produced by computer. Does Section 84 also apply to police reports or medical reports that are merely computer type? printed and sought to be tendered as evidence in court. Do I repeat it, sir? Okay. So I will want my Lord to address it so that the participant from afar, I think is in Port Harcourt or somewhere, can, and then one of them has Rose Briggs. I don't know whether this name is familiar to my Lord or to the panelists. I guess that Rose must know Mr. Aroko. He said, excellent presentation. Thank you, sir. Well, there is this also to the fact that at what point is a certificate required under Section 84 to be tendered in a criminal trial, taking into consideration the fact that documents are not being front-loaded as we have in civil proceedings. This is peculiar to criminal trial. Is trying to know at what point do we put in the certificate in a criminal proceeding where there is no front loading. Is it when we are about to tender or after we have tender or what? So this is from one of the participants here. Oh, Mr. Adedayo Adedeji. So when my Lord is through with all this, then we can now move to the general floor so that before we... Thank you very much, my Lord.
Thank you very much, Mr. Chairman. Before moving to the general floor, I already have a truckload of questions here, beginning from your question. Well, why can't we waive Section 84? I think that was essentially your question in respect of Areori and Elemo. My answer to it is not to defend the Supreme Court that said in Cuba and Dixon that the conditions under Section 84 are preconditions which must be fulfilled. Otherwise, such documents should be rejected. I want to see us as developing. I said it in my conclusion. Electronic evidence is dynamic. Like Lanesig Offiong mentioned, there is this slow pace of our legislation. Where we borrowed Section 84, essentially Section 69 of the Pace Act of England. Just the same way, well, mutatis mutandis. It's like we reproduced that Section 69 of the Pace Act and made it our Section 84. That section of the law in England has been abrogated. You know, that is a development. That is an advancement in law. In England today, there is no provision, there is no requirement of fulfilling conditions similar to Section 84, our Section 84 again. How does a council tender an electronically generated evidence? An electronically generated evidence in England is presumed to be authentic and admissible, subject to any objection. And the onus is on the one who objects and says that that document is not authentic. It is you that you have to prove it. Singapore has followed that example. They now have their law presumptions incorporated into the Evidence Act. For instance, a computer that produces a document is presumed to be working well until the contrary is proved. and the document itself is presumed to be authentic until the contrary is proved. So that is the stage, you know, the law in advanced countries, you know, has reached. And I want to believe that maybe one day too, we may get to that level. And so I think that will be my answer, that basically we have only updated the law, what the law says in Nigeria as of today. But we hope that the law will develop beyond this point in future. Now, Nalen Singh also mentioned something about, that is Offiong, SAN, tendering camera, requirement of tendering camera as required by the Court of Appeal decision. So in a Budon case, that case, well, ordinarily Section 84 does not require the tendering of the device itself. Because when you talk about phones and what have you, those are the devices, the computer, you know, the device that stores, that transmits, that, you know, like our phone here. So the camera too falls within the definition of a computer under Section 2 of the Act. And therefore, what Section 84 actually requires is admissibility of a statement contained in a document produced by a computer. Like Rokoro, SAN has said, you have this computer. Of course, what is relevant here is the information contained in it. So, statement contained in a document produced by computer. So that statement is contained here, and you have two options, either to print it out or to tender the phone itself and refer to a particular page within it to prove your case. I think that was what this Court of Appeal was saying in that case. It is making it a requirement that there's nothing wrong. I think the position is not as if it must be tendered. And if that is what the Court of Appeal is saying, that may not be the proper position of the law, with due respect. The requirement, you are not required, but nothing stops you from tendering the real evidence, like he said. Sufficiently, you could print out and tender. But then, are not included the and leading evidence to show what you want to establish. But the objection will be that a printout from this phone now will not be admissible because this phone is not tendered. I don't know whether that point is clear. It's a matter of alternative. And you cannot say because one is not tendered, the other will not be admissible. And I'm sure that was the problem in the Court of Appeal decision. So you can tender, you can take it. There are two approaches: download, print out, tender. Tender the device, lead evidence to the material or the information you want to tender. But the law does not say because you do not tender the device, the printout will not be admissible. I think that point is made. Oyekomi, presumption, well, you see, maybe I should, like I have mentioned, that we are getting to a point of presumption. We may likely get to a point of, if we can move with time, but you can see how slow we are. So, but like somebody mentioned, courts, we have to be proactive and see beyond the present and go beyond what is happening now, move with time. And so I believe that a time will come when such
Yeah, this one is ready.
Mr. Dedeji asked a question at what a certificate in a criminal case under Section 84(4). The law does not specify the time. For instance, our law is different from the law of India in respect of on this matter, because this certificate that we require, the form required in India is affidavit, and it should be attached with that document. Our own Section 84 does not say we should attach the certificate. That if it is attached, it does not render the document inadmissible. Perhaps, but like he said, we don't front load cases, although evidence or facts, materials in criminal cases. But then there is what we call proof of evidence, which of course must be before the court and must have been served on the parties. Amongst the what is required to prove a criminal case, of course, in a electronically generated evidence must be the certificate. So presumably a certificate must have the proof of evidence must contain the certificate. So if, of course, evidence is rendering evidence is a process. If somebody is in a witness box and he gets to a point where he tenders this document, maybe first, this is the electronically generated evidence, and the other counsel raises objection, and the objection relates to the absence of a certificate, I think it is expedient at that point that certificate should be tendered instead of engaging in argument, because I know that is the practice of lawyers. You have the document with you, you have front loaded it, and of course ultimately perhaps you intend to tender it, presumably in any event, by the fact that you have made it part of the proof of evidence presupposes that you want to tender it. And somebody is now saying that he's objecting to this document because the certificate, what does it take for you now to, okay, witness, can you see this document? What is this document? It's a certificate. I seek to tender it. I don't know if these are practical issues that we face in court. And it's not a matter of what you can read in textbooks. It's a matter of experience. I am speaking by virtue of my position as a trial court judge. I know I regret and I lament seeing lawyers some of the times arguing over nothing. You have a document with you. Somebody is saying that document, or your own document you want to tender, the one that you have not tendered, which is in your possession now, is going to use it to object to the inadmissibility of this, and you now engage in argument. I don't know what type of argument. So my practical answer is that immediately an objection is raised to it, if you have it and you have it as part of your proof evidence, just take it in and say, this is the document. Now, the last question has to do with, is it just any document that Section 84 applies to? Learned Sikh Ofiongo SAN2 has virtually answered it by referring to the recent book of Horn, S.T. Horn, which I have read too. In my own book too, I addressed that issue. You see, computer can be used for so many things. And one of the simplest ways, one of the simplest things that you use computer for is as a typewriter. You want to type a letter, and you type it, and you print it out immediately. Does Section 84 apply to it? Section 84 is all about authentication. If you write your letter, you are going to sign it. Your signature on your letter is sufficient authentication to render that letter admissible. If I type my own judgment in my court and print it out in my office and sign it, or my registrar satisfy it, I have only used computer as a typewriter. And so the same thing with all these medical reports and what have you. The medical report, the doctor, perhaps after examining maybe a corpse, now expresses his opinion in a paper and gives it to the typist or the computer operator to type out. And the operator brings it back to him and he signs. So the computer has only been used as a typewriter. It is different from an email that has to go through so many protocols that has to be transmitted. So in this regard, just the way S.T. Horn has put it in his book, it is not anything that passes through the computer, because computer can be used and in particular, note that where computer is used as a typewriter, the authentication will relate to the signature, the physical signature, which will be sufficient to render such a document admissible. Thank you, sir.
Another round of applause for my Lord. We thank my Lord very much for taking you through all this and for all your time, your dedication, your diligence, and for the gratuitous knowledge which we have taken this. We owe you gratitude. We are very grateful. Collectively, singly, totally, everything, we are grateful to my Lord. Well, this is the floor is now open. But you know, my Lord is a judge. He still remains a judge. So you put across your views gently and mildly. And we're going to entertain just 5 questions or 5 clarifications or contributions. It doesn't have to be a question. Maybe contribution, and you heard the way I frame my own. How about this case? Not, don't you think that position is wrong? Not you. So, I don't know if anybody has anything.
I don't know if I could be accommodated now.
Who? Oh. Okay, sir. We will accommodate you, sir. We will accommodate you with a fine.
Thank you very much. Let me first start by acknowledging the immense erudition of the lead presenter and the presenters who have done justice to the topic at hand. I just want to, I really wouldn't comment on the issues arising in Rose Hill against GTV. I think the Supreme Court will sort out the situation at the appropriate time. However, I think, let me just go straight to this intriguing aspect which has been discussed today, which is the aspect of having the equipment itself tendered in evidence as a means of establishing authenticity of the content, which is also equally limited. I note the the position of Mr. Rokoro is saying is a very ingenious distinction of real evidence as opposed to the other aspect of evidence, that is the context in it. That is the electronic evidence that is being extracted from the real evidence. Now, let me give an example. Perhaps my example will explain the dilemma we have in this issue. When we were doing with Kogi governorship election, I'm sure the chairman will remember, and a few others, it got to a point where a strong part of the petitioner's case was corrupt practices and violence and general things that happened in the course of the election that rendered, in their view, the election unsafe to sustain. And they brought a video showing a helicopter hovered. And part of the evidence was that shots were being fired from the helicopter. And they brought a CD, intended it, of general acts of what in their view appeared to be corrupt practices that took place in the election and violence. What we saw in the video was just a helicopter going around, nothing else. So that was tendered and properly objected to. But you know, the position now in election cases is that you will state your grounds of objection in written address. So we all reserve that. But he hinted that we were concerned about the authenticity of this video. And indeed, when the video was played and we had to cross-examine it, was clearly, the distinction was clearly brought up that what was now being played in court was an edited version of what the camera took. So, Learned Senior Counsel then knew that it behoved on him to tender the camera itself, or the device that took the film. And so he sought to bring a witness. On the afternoon that the witness would give evidence, when we came back from break, he announced that the witness had been kidnapped, hijacked, and taken to Zuba. On the way, he was thrown out of the vehicle and the phone got damaged, thereby saying it was impossible to tender the phone that took the pictures. I think that this is a practical demonstration of where the hardware is a necessary evidence, inclusive of the software. In this situation, we are not really concerned about the edited version that came by way of the CD disk. Had the phone been tendered, we would have gone into the hard drive to see, one, the date it was made, and two, whether they were implanted on the hard drive or whether it was taken on that date. So from the day we did that case, it now came clear to me that there is some sense in some situations asking that the hardware that took or that prepared the electronic evidence ought to be tendered in evidence so that we could go into it. And this is in a bid to establish one of the conditions set out in Section 84, particularly in Section 84.2, which is the authenticity of what is being brought. We all know election cases that people go to very great lengths to try to advance the cases of their client. And one of the features of electronic evidence and the lead presenter reminded us about a situation whereby he narrowly missed the photograph, the group photograph of a course in Cambridge or Oxford. And later, having such affirmed that he was diligent throughout, and it was exhaustion, the excruciating nature of the conflict, made him exhausted and he missed the group photograph. And he needed to bring the group back to show those who sent him for the conference. They still were able to make him appear somewhere in the group photograph after taking a picture of himself. Now, so you see, electronic evidence can be subjected to a lot of modification, whether original, whether in this case it was genuine and altruistic. He attended the conference, he participated, he only missed the snapshot, and therefore it was for a good cause. But in an election, it could be for a mischievous cause, trying to remove somebody who was validly elected and putting somebody in. You have doctored evidence being brought in. At times, the arbiter, the decider of this situation would be the hard evidence itself, what Mr. Rokoro calls real evidence. So therefore, I think with that experience, I began to see the wisdom in the Court of Appeal case, which say at times, or you need to tender the hard evidence, the real evidence, alongside with the intellectual evidence. So that's just my short intervention in this matter, because it's an ongoing discussion. Thank you, Mr. Chairman.
Thank you very much, Coordinator. We owe you a lot of gratitude for putting this together, and we shall always be at your attention. God bless you. Thank you very much. Now, a round of applause for him, even though he's not seeing us. Another one. Okay, see us. Okay, that's very good. Okay, all right. Thank you very much, sir. Thank you, sir.
Thank you.
Did you hear the applause?
I did.
You're going to ask? You introduce yourself briefly?
Sorry? Okay.
In an electric.
Yeah, good morning, Chairman and a panelist. My name is Samson Egege. I'm from Didi Dodonko. My question is for the lead presenter, and it relates to the mandatoriness of Section 84, Sub 2 and 4. And your Lordship had said it is important that apart from the certification, that oral evidence is led. Now, my question is it not superfluous to require oral evidence where there is a certification that contains those conditions substantially, and the certificate is tendered through a witness, meaning the other party has the opportunity to cross-examine that witness on the content of the certificate. Now, I ask this because the basis of the decision in Kubo and Dixon is because the certificate was tendered from the bar. Now, if it was tendered through a witness who identifies the certificate and is cross-examined, now regardless of the absence of his oral evidence contained in a witness statement on oath, say it's a civil trial, would that invalidate, would that render the document inadmissible? I don't know if I can ask a second question. Okay, my second question relates generally to this idea of authentication. Now, do we not think that Section 84 has rather rendered evidence that should ordinarily be admissible inadmissible? Now, I'm asking because all you are required to do, I'm tendering a document which I produced from my computer, and all I'm required to do is to say this document was produced from this computer, the computer is in regular use. Does that really, in actual sense, authenticate the document? Because I am the one bringing the document. I'm not going to say the computer is not in regular use. I'm not going to say there is any defects in the process of producing this document. So looking at justice, do we really need Section 84? Because I think Section 84 has helped in, throwing out documents that are relevant to deciding a lot of cases. Thank you very much.
It is similar. Why do you want to visit it? Okay, go ahead.
Good. I'm loud enough. No, sir. Okay. OJ Onoja, SA and Associates. Yes, sir. My name is Mimi Ayua. Good morning, my Lord, and Mr. Chairman, and distinguished panelists. Thank you so much for the opportunity. So my question is just to follow up on his first question, but I'm going to relate it directly to the case which the lead presenter referred to, Impact Solutions Limited and International Breweries PLC. So does that mandatory requirement for a viva voce evidence in support of your certificate in your written address? I beg your pardon, witness stating on oath. So my question is this. So assuming you do not categorically refer to make those requirements in your witness statement on oath, how can you remedy this without having to amend? So is there a way, can you do this during your examination in chief? Can you find a way to ask the witness to refer to those requirements without having to amend? So that's just my question on that. My second question basically is that these days you prepare a document, maybe an agreement, and then you send it, you could send to the parties, and then they electronically sign the document, and then forward to the next person, and you print out a copy. Where will this agreement fall into? Will it be covered under Section 84, or it's a normal document that does not require all of provisions in 84? That's just my question. Thank you very much.
Mr. Sampson, tendering just a mere certificate without oral evidence. Before Section 84, the law is clear that document tender not linked up with your case with oral evidence will go to no issue. And that is the principle is not different. You have a certificate in the first place. The practice is wrong to reproduce all the conditions under Section 84.2 and put it under Section 84.4 to say that you have fulfilled all apart from there are specific requirements under Section 84.4, but in relation to Section 84.2, all that Section 84.4 requires is any of the conditions. Just one will be sufficient. For instance, Section 84.4 requires identify the document, the manner of production, particulars of the computer. You know, all these are not in Section 84.2. Then, in addition, any of the conditions stipulated. But like I said from my experience, what I see in court is people will reproduce all the conditions in Section 84.2 and put it in that certificate. And now they will tender and expect that that will take the place of oral evidence. It will go to no issue. It is the law. I mentioned it in my paper too, quoting Uwenze, JSC, that if your oral evidence is not linked up with your document, it goes to no issue. I think it settles that one. Kobo and Dixon, it was not simply because those documents were tendered from the bar. Read it very well. It was tendered from the bar, but the Supreme Court also found that there was nothing in the evidence of oath of the witness to fulfill those conditions. you know how you have mixed it up now. You said it was tender from the bar and conditions were contained in the statement or note. No. Go and read it. One of the reasons why those documents were rejected was that the statement or note was afflicted by the absence of the conditions under section 84.4. So, two reasons. Tendered from the bar, and I mentioned in my book, the fact that it was tendered from the bar is not a reason why any document should be rejected. Because if those facts required under section 84.2 are contained in the statement or note of a witness, and from the bar seek to tender it, and with the consent of my opponent, there is no reason why it should not be admitted. I argue that point is there. So then, section 84 is what you are to establish is a prima facie case of authenticity. When you satisfy this condition, what you are telling the court is prima facie, this document should be admitted. And the mistake we make most often is the fact that we tend to equate admissibility with weight of evidence. Whereas there are two different sections under the Evidence Act dealing with admissibility and weight. Section 34.1 is about the weight, and the law requires under section 34.1 that the court should take all the surrounding circumstances into consideration. Do you understand? So all these issues that we are raising, they are in fact issues that the court at the time of writing its judgment can take into consideration, not give way to an admissible or admitted electronically generated document. So it is, I always know whether I did it in my book, admissibility, all it takes is somebody is coming to your house, go to the door, you say yes, come in, and he enters. That is all. What he came for, you don't know. If he now comes in to say, I have come to seek a loan of 1 billion naira from you, I think you will say, thank you very much. Please, can you just find your way out? You have not given any consideration to what he has said. So that is the difference between admissibility and weight. It's a practical example. So please, I want you to draw attention to this. Then, if facts, my sister, Ayua, if facts are omitted in the statement on oath regarding the conditions stipulated under section 84.2, what do you do? My advice is swear to a further. You cannot amend an oath, you know, because if you say it's an oath, you have, you know. So I think the practice is to swear to a further affidavit to show, to fill in the gap. So it is not a position that is not irremediable. Then, sorry, your second question, I beg your pardon.
Thank you, Milord. My second question is, what if you prepare a document, an agreement, for instance,
Yes.
and the parties are not physically present, you send agreement to them, and they sign electronically and send it back, and you have to print a copy? Would that document be properly covered under section 84 as an electronically generated
Okay,
document?
well, I think it falls
PFR put it.
Okay.
Is that one, is the type, is the
Yes.
computer there just used to type?
Yes.
Is it just
Yeah, of
typing
course.
purposes, or is that agreement will now have to satisfy the conditions in 84?
It depends on the manner in which it has been sent. Did you send it by email? In any event, you said it has been electrically signed. So that makes it electronic evidence. What you want, the one you print out, is not electronic signature. Electronic signature, you know what it is. As a matter of fact, there is no specific signature that is electronic signature. Anything can be electronic signature. If me and you agree that my name is Alaba, after a document, I will just type AA. That is electronic.
My lord, we have, okay, so we now have devices and apps or applications where you can actually impute your signature and just send it on
Yes,
a
yes.
hang. So
Yes, I'm talking about the simplest way, of the simplest definition of electronic evidence. You don't have to use that app in order to secure an electronic signature. Yes. So it depends on how it has been transmitted. If it was transmitted through email, and I don't know how you will transmit without using email, and of course it has to be electronic, it must have been electronically generated. Thank you.
Thank you very much. While you were attending to them, somebody sent in a question that goes this way. During the recent NSAS protest, an incident occurred where live videos were streamed. However, there are allegations that the videos may have been photoshopped or manipulated. For the cause of trial, how will the conditions under Section 84 be fulfilled? Sorry, sir. What he's saying is that, let me read his words because I don't know the meaning very well. During the recent NSAS protest, an incident occurred where live videos were streamed. However, there are allegations that the videos may have been photoshopped or manipulated. For the cause of trial, how will the condition under Section 84 be fulfilled?
Okay. Lanes, you want to add to?
No.
Oh, okay. Lanen Sik Rukuresi, and he addressed the issue in his paper.
Okay.
But before he answers it, well, video clips from NSAS of so many things that happen in Lekki. The question assumes that the matter will be taken before a court where Section 84 applies.
Yes.
And is asking now, how do you fulfill it? In the first place, to just allege that an electrically generated evidence is a Photoshop in a casual manner, the way it is being alleged here, the objection will not hold any water before the court of law. You see, because to raise an objection that it is Photoshop, it means you have evidence that it is Photoshop. He who asserts must prove. To establish to tender those videos, you download the video either into a CD or whatever it is, or a flash drive. You tender the video, of course, establish the fact that one, your camera or whatever device you used worked well. From the time you capture the event, nobody has tampered with that. You just establish those conditions to show that what you are tendering is authentic. Like we said, prima facie, if you show that what you are tendering, the document you are tendering is authentic, it will be admitted. Whoever has any reason to the contrary, we have to produce the evidence. So if you say it is Photoshop, what evidence do you have that it is Photoshop? That is my position. Lanesik.
speak on it because I had referred to that particular incident in my paper. Now, the Nigerian army at first, of course, you recall, reacted by saying that videos of soldiers at the NSAS place shooting at people were photoshopped, that they were fake. Now, the position in Nigeria, even though we bandied Section 84 about so much, is actually the same as in the UK and in the US. And I think some of the most clear statements on this, in the case of United States and Savebian, where I think, let me quote what the judge said. He said, a trial judge should admit evidence if there is plausible evidence of authenticity produced by the proponent of the evidence, and any speculation or conjecture, not fact, by the opponent of the evidence about how or by whom it might have been created would be question to be established by that other party. Now, it is possible to determine clearly now whether a particular electronic piece of evidence was tampered with or not. Of course, you don't expect me or any of us here to know the full physics behind it. But there are things now called hash values, which are mathematical ascriptions of identification, which are as precise as DNA evidence. So if you take a particular piece of electronic equipment and subject it to a particular algorithm, which they know how to create, it can tell you the features of, it can break every bit of that data down and give it values. Now, if you then compare that with some other document that claims or a copy, which is not authentic, it's very clear, it's very easy to determine. Secondly, you have advanced forensics now. You have practitioners in these areas who actually have the tools and gadgets that can determine when a particular video was made, the date, the hour, the time, can tell you the equipment that made it, and more specifically, they can tell you whether a particular equipment made it or not. So if those videos are tendered and the Nigerian army or whoever, okay, first of all, about admissibility, my lord has already made the point that they will be admitted if the conditions in Section 84 are met. Yes. So prima facie, the document will be before the court. But it is possible, we must acknowledge, it's possible that they were photoshopped. It's possible that they are genuine. Now, that's one of the things that my lord and I refer to in our papers, that the court system should by itself have that capability today. And many courts around the world have it now, where you subject that piece of electronic evidence, put it in that system, and it will tell you right away whether this is an original, genuine product or whether it has been tampered with in any way. So the technology is there. The only question is, do you have the resources to determine it? So for instance, if that document goes in and the army insists that they are photoshopped, the army will have to find the expertise to come in and examine that document and see whether it is authentic or not. So really, there isn't much of a difficulty as regards admissibility. It's as to how the court will come to the decision whether to rely on it or not.
Very much.
Recently, I was involved, I have been involved in a defamation case. And one of the issues arising from that defamation case is also this video clips. So I've had an opportunity to sit with a number of highly qualified persons in the area of forensics, the technology involved in determining the genuineness or the truthfulness of the contents of the video clips. What has been of concern to me are two things. Number one is that each time we talk about authenticity of the document under Section 84, Okay, my Lord has used the word prima facie. So I think it is about a test of should we admit this and look at it, and that test is which computer did it come from? How was that computer kept? Who is the person interfacing with it? So that gives you an idea of where it comes from. But the experience I had talking with those gentlemen was that there are deeper issues with regard to not just whether it came from this computer, because if you have a video, you can pass a video to me, I can pass it to somebody else, and the person can then produce it from his own device. And he can tender it that he produced it from his own device. But the question will still remain, what is the credibility of the information which is being passed around in it? And I think that that issue goes to weight. In my interaction with those professionals, what I found in the conversation was that some of what Mr. Paul has mentioned, that there are clearly algorithms which determine that, in fact, what they said to me is that once the video leaves the original device with which it was produced, its reliability is in question. That the only way you can actually ascertain the genuineness of it is by it being preserved in the original device. In fact, in one case, so for instance, the mobile phone, they said if you switch off the mobile phone and then you switch it on again, it will distort the information. So, the intervention I'm trying to make here is to say that, look, we must go beyond the formality of it. If you are involved in cases relating to the genuineness or authenticity of a video clip, you must simply go beyond the formality and look to experts who would be able to guide you with regard to how you can question and establish the genuineness of what is being presented in the court. Otherwise, that artificial information will not be very helpful.
Thank you very much, Chivu Ibiu-Fion. I am calling the last intervener, speaker, Paul, to make his contribution.
Oh, thank you very much. My question is to all the resource persons, and it's just it's a question that came up in light of this NSAS protest and the issue that happened at Lekki. I'm giving a hypothetical situation, although you can draw your conclusions on what happened. What if I discover the scene of such an incident, a device, and the maker is dead or not available to testify?
You mean, what if your name is Fashola?
I never mentioned any name. I see a device and I'm not the maker. And can it be presented? And then what if the maker of the electronic evidence in line with section 84 is not available for reasons beyond the person's control? Is it still equitable to throw that evidence out because section 84 requires a certificate from the person who made it? What if that person is not available due to reasons beyond his or her control? Thank you.
Am I the expert? Okay, Mr. Paul, you know, we have said that authentication is not hard and fast rule, really. Circumstantial evidence can even authenticate a document. So it depends on the circumstances. the first scenario that you created, you just found it. So what is your business with it? So, that document will be admissible to the extent that you found it. And that is the document that you found, Exhibit A. But for you to establish the contents of the document you know nothing about, you don't know how it was produced, you don't know how it was, the computer that was used or anything. The question is, how will you satisfy the conditions in there? So that's why Fashola will have problem. If he has to appear in court in respect of the those documents he said he found, the video that he said he recovered, he knows nothing about how it was produced, but it will be admitted to the extent that he actually found that. Yes. So I think that clears it. Now, the second one, where somebody is not available. By reason of what? Why is he not available? By reason of death? Or he ran away from the country. Now, what do you want to tender the document to prove? A particular event was broadcast live. Okay. Okay. So, if you are coming now, you are coming to give evidence about what you read from WhatsApp or what you saw on Twitter. You are not the one, you are not the maker of it. So, you can't go beyond that you are a subscriber to Twitter and you read this one and this is what I read and I want to tender it. So the truth of that matter, you are not in a position to, I am not sure you are in a position to establish it. And that is, like I said, process of admissibility is very elastic. As a matter of fact, it is open. Until now that we have this section 84, on a personal note, in my court, at the point of tendering evidence, I hardly reject documents. Because from experience, I discovered that too, that if by error you reject a document, and at the point of judgment, you discover that you ought not to have rejected it, you will put your hand in the finger and you will bite it to the end and you will be helpless. You will regret your action because you cannot readmit it again. But if you admit, this is practical, if you admit and at the judgment stage you find that it is not admissible, you reject. So I think it's a better approach. We have to be elastic. As a matter of fact, in my book, I recommended liberal approach to admissibility of electronic evidence. Liberal approach. And if we adopt that one, the opportunity to re-examine what you have done will still come. But just at that stage, to just reject and throw it away, well, I have done it before, and like I said, I regretted, not on electronic evidence, but I regretted it. So, be liberal, be open to admit documents. Thank you very much.
Well, we thank my noble Lord, Mr. Haruna Goro. You are welcome, sir. You are welcome. Congratulations. Congratulations. Have you brought the wine? Eh? No. Before confinement, otherwise we would brought the wine. Eh? No. Before confinement, otherwise we would delay. Yes, you have something to say, sir?
Mr. Chairman and panelists, my name is Richard Oma Ahona Rogo. I'm happy to be here, and this is an area of the law in which I find a lot of pleasure. My worry now is what will happen to documents that have been tendered in the original form before the courts of trial and have been destroyed in the NSAS process. And now trials will have to start de novo, witnesses will have to be reassembled, and especially in criminal cases. Let's give an example of the NDLEA cases, where substances, I don't want to mention them, have been kept in the custody, the vaults of the courts, and the courts have been rendered to arches. Can a trial de novo lead to anything? That is number one. Number two, in the civil cases, land cases, C of O's, survey plans, documents of monumental nature have been destroyed. And because of our filing and archival system in this country, they cannot be brought back. What happens to those cases? Thank you, sir.
Well, incidentally, it's not about electronic evidence. Although, it doesn't matter. Well, the point I want to bring out in respect of what happened in Lagos is the need for the judiciary to be protected and to be adequately protected for that matter. Probably, if we had sufficient protection, what occurred, like you said, in Asaba and Lagos, will have been prevented. This is a big problem that we are facing, and in all honesty, sitting down here, if those documents, original documents, if secondary documents, versions of those originals are available, of course we know it is still possible, because all you will need is to lay foundation for the admissibility of a secondary evidence on so, there was this violence, there was this arson, there was this and that, and the courtroom, the original was burned. I seek to tender that. But where the secondary evidence of those documents is not available, I think it will be a very serious problem. And my guess is as good as yours. I mean, on how to get that problem resolved. Thank you, sir.
Well, Mr. Richard, we thank you for your last comment. And I think you have presented a scenario which is very tasking. I believe legislative intervention, ad hominem laws, may have to come in at this stage. It's not usual for you to have a statute to address specific issues. But when you have an unusual situation like this, maybe some ad hominem laws or specific provisions in the law to address all these kind of things, to take care of, because it will be monumental injustice or failure of society to the people if nothing is done. With that, I want to thank my Lord.
The records of the court. Yeah.
Perhaps the law can create an avenue for them to go and resolve all those disputes. Yeah, to take it outside the penumbra of the court. Once the matter can prove that it was listed. Hello? I'll call you.
I think
have
Mr.
passed the
Chairman,
time.
before you round up,
We have passed the time.
I think Mr. Chairman,
Oh, sir.
before you round up,
Yes, sir.
Yeah, I just wanted to seize the opportunity before you round up on this point. In contribution to what the learned SAN said, Mr. Richard Omonobu, I think that this is the time where the judiciary, like the lead presenter said, must invest. Had these exhibits, the records been clouded, and there's so many cloud facilities, Microsoft, Google, many of them, had there been existing laws to say 7 days after a proceedings, the proceedings of the court must be copied and clouded, everything would have been retrieved now, and we would have had the last laugh on these people. So I think this is the time for the judiciary to really utilize its vote for concrete things like that, because that may not be the last. And every 20 years we come around to situations where courts are destroyed, records are burned. But if these records can be put in retrieval systems in the cloud, 3 days afterward, the courts will begin to sit again, because you can't go and burn the satellite in the cloud. So I am urging the organizers to make it one of the issues in the community that going forward, the judiciary must put in place a uniform way of document retrieval, electronically or by internet. Thank you, sir.
Just to add to that, the banks are doing it. They have continuous banking operations, so that if the records are lost in the bank, they will always find them. It's compulsory.
And because the banks have money, the courts don't have money. No, look, what also can you lay claim to the money if it's your money? Can you lay claim to Zenith money or Diamond Bank money? You see, it's your money. Well, I thank all of us, especially my noble lord, the Learned Six, the gentlemen from Dodo, from everywhere, from the press who have been here all day, and I can see NTA. Yes, I can see NTA here. You are most welcome. Is a major topic which is very, very germane, and it addresses contemporary issues, because now the coordinator has spoken about the cloud. It's all about technology, which we are running away from. And if society cannot take care of all these things, then it's a failure of a society. If the banks can do it, why wouldn't they fund the judiciary to be able to do that? That is, you dematerialize the documents. And a lot of outfits that are there to do that. On behalf of the foundation, I want to thank all of us, although Paul is going to do that. And we wish all of us journey messages to our respective destinations. And we hope, God willing, we'll all be able to make it again next year as another program will be organized. I'm very grateful, and I thank my noble Lord in particular. Have a wonderful day.
Let us give the panel a resounding round of applause. We have had a very robust discussion on electronic evidence, and fortunately, we have even gone some minutes beyond the allocated time. That shows the dedication of our panelists. They are very busy members of the legal profession and senior members of the legal profession. The lead presenter, we want to thank you for associating with us, and we want to also commend you for acknowledging our role in inspiring you to produce your literary works on this subject. And I'm sure many of our conferees are always interested whether your book is available. A lot of them like to pick it up in these conferences. I'm sure you came with some copies for our conferees, and I'm sure they will be available. I will not be able to disclose the price here, so I'm sure if after you can see us on that. So my lord, what I'm saying is that thank you very much, and we're very grateful, I know you will still continue to be with us as you are for the other sessions. To my very, very eminent senior, Paul Erokoresi, I want to thank you for I fondly call him Uncle Paul. He has really done justice. Fortunately, I even read your paper because it's a bit shorter than my law's paper, and I read it, and I honestly want to commend you for the industry. You could have even served as the lead paper. I want to thank you for making out time despite your busy schedule. We're very grateful to you. To our learning senior advocate who has come all the way from Kano, sir, I want to really appreciate you on behalf of the foundation for taking out time to add to the jurisprudence in this very important aspect of criminal procedure, and we thank you so much for your time and your contribution so far. And I left the chairman as the last. You could see even in the course of he was receiving calls because as one of the panelists hinted, the money is there. And we have taken so much time from you, sir, and we're indeed very grateful for you steering the ship in the way you did this morning, Learned Senior Advocate. We are very grateful to you and wish you safe journey to your home and your destination. Thank you for being with us. To all our distinguished conferees, thank you. I know we have eaten into your lunch time, but the session couldn't have been what it was without the interaction and contribution we got from both those online and those here. So I want to thank you all for your rapt attention and your contribution to the Rule of Law Foundation. So this will be the end of this session, and I understand that for those of us who are the secretariat, our lunch is ready, and will be directed after the session closes how the lunch will proceed. And this is to remind you that the next session will start by 1 o'clock. And the next section is on electronic evidence, but outside is on substantive evidence, updates in substantive outside electronic evidence. So a general overview of evidence, updates, the latest authorities, especially I can see aspects of expert evidence and the rest that will be taken by 1 o'clock. And that will be chaired by no other person than Atoibi, Senior Advocate of Nigeria. And we have our head of chambers also up as part of that session, Adida DDG, Junior Sibega. So we look forward to that session coming up at 1 o'clock. And so let us endeavor to have our lunch timelessly so that we can come back in time. So thank you everybody, and I wish you a pleasant day.